The child froze to death in a manner of that
believes she went into the slough to do him any harm, let alone to kill her son.
I lost my grandson that day because of the actions of my daughter.
I didn't do it because I wanted to, because I wanted to inflict. I didn't try to kill her. It was a total accident.
Robert Lindsay, a former New Albany High School student, was charged with the murder of his mother, LaTonia Banner. The incident occurred in February 2013 when Lindsay, then 19, argued with his mother at their Northeast Columbus home. During the altercation, he stabbed her, resulting in her death. Lindsay also sustained a stab wound to his leg, but survived. Neighbors described the family as quiet, with few interactions.
You are a murderer in every sense of the word.
The courtroom was filled with emotion as Robert Lindsay's aunt spoke, her voice trembling with heartache.
The knife that you used to stab her continues to pierce our family. The pain never ends.
The judge then scolded.
The night that your mother was killed, you said you went back upstairs. You didn't hear her moaning, you didn't hear her groaning, you didn't hear anything because she was already dead and you knew it.
During the trial, Lindsay testified that he acted in self-defense, claiming his mother had been abusive. However, the prosecution presented evidence suggesting premeditation. The judge remarked on Lindsay's acting skills, indicating skepticism about his defense.
I didn't do it because I wanted to, because I wanted to inflict. I didn't try to kill her. It was a total accident.
This court saw the greatest acting I have ever witnessed since I've been a judge. You're professional. You're a professional actor.
The judge denied the claims of self-defense, and then Lindsay was sentenced to life in prison for the murder of his mother. He will be eligible for parole after 15 years. Tywayne Robinson, the accused in a deadly shooting, took the stand in his own defense during his Fresno murder trial more than 3 years after the incident. Robinson, facing charges of murder and attempted murder, shared his side of the story with the jury. He testified about his past encounters with the victim, Isaac Jackson, revealing that he often saw Jackson with a gun. Robinson explained how their relationship had soured, and he described the fear he felt in the moments leading up to the shooting. According to Robinson, in May 2021, 2 men, including Jackson, showed up at his doorstep in southeast Fresno. Robinson claimed that he was in fear for his life when the shooting occurred, leading him to take action. His testimony painted a picture of self-defense as he explained the events that led to Isaac Jackson's death.
I was feeling scared.
What did you think would happen if they came in?
I honestly thought that I was either going to be shot or killed.
Tywayne Robinson then testified that he opened from inside his apartment, and killing 24-year-old Isaac Jackson, while also firing at Jackson's friend, Terrell. The 2 men had come to the apartment to check on Robinson's partner, who was also Jackson's niece. While investigators found no evidence that anyone else was armed, Robinson insisted that he believed both men had guns, which led to him firing in what he described as self-defense.
I seen Isaac in front of the door with no shirt, and he also had a gun in his hand.
Robinson further testified to the jury that he had always known Isaac Jackson to carry a firearm, including during a previous encounter with his partner's family in Palmdale.
He pulled his gun out and made it seem like if I didn't leave, he was going to shoot me.
On the day of the shooting, Robinson also recalled arguing with his partner and her mother.
She told me that she was going to send someone to my house to kill me.
He explained that this was the reason he decided to open fire on Jackson and Terrell.
I thought they were making their way in, so I fired once through the door and twice at the wall.
In October 2024, a Fresno jury found 36-year-old Tywayne Robinson guilty of murder and attempted murder. Denying the claims of self-defense, the jury convicted him on both counts. Sentencing is scheduled, with Robinson facing up to life in prison. In February 2015, 23-year-old Samantha Green was found in a distressed state near a slough in Knights Landing, California. The following day, authorities discovered the body of her son, Justice Reese, in nearby bushes. An autopsy indicated that Justice might have died from hypothermia or drowning.
The child froze to death in a manner of that can only be described as slow and agonizing.
Green was convicted of second-degree murder in the tragic death of her son, Justice Reese. During her sentencing hearing, her family and public defender made a heartfelt plea for leniency.
There is not one part of me that believes she went into the slough to do him any harm, let alone to kill her son. There is no way.
During the emotional sentencing hearing, Samantha Green's family painted a picture of a once dedicated and compassionate young woman. They described her as someone who deeply loved animals, often rescuing strays in need. Green had been active in the ROTC program, with aspirations of building a career in the Navy. However, her bright future took a devastating turn as she fell into the grip of drug addiction.
What happened on February 24th was nothing short of horrific. I lost my grandson that day because of the actions of my daughter.
Greens admitted that she had made serious mistakes and could be considered a criminal by her actions, but they firmly argued that she was not a murderer.
That day, she got high and had such a terrible trip that she had a psychotic episode and thought she was protecting our grandson from someone or something.
Despite the emotional pleas from Samantha Green's family and public defender, the judge firmly disagreed with their arguments for leniency.
It really is a tragic case all around. You violated the most basic responsibility of a parent. You put your child in harm's way.
Found guilty of second-degree murder in the death of her son, she is enduring the weight of her choices, with a sentence of 15 years to life in prison. In July 2015, a tragic incident unfolded in Madison County, North Carolina, involving a mother, her son, and his girlfriend. Nancy Cherie Hogan, her son Brandon Hogan, and Diane Chapman were implicated in the murder of 67-year-old Edward Prater.
Did you kill your mother's ex-boyfriend?
Brandon Hogan showed no reaction as deputies escorted him into the courthouse. Moments later, his mother, Nancy Hogan, was brought in, also remaining silent as onlookers watched. Once inside the courtroom, the district attorney addressed the gathered parties.
These are first appearances for Brandon Thomas Hogan and Nancy Cherie Hogan.
Brandon Hogan and his mother, Nancy Hogan, stood separately in the courtroom as the charges against them were read: capital murder, conspiracy, armed robbery, and trespassing. Both remained expressionless as the judge ruled they would be held without bond, emphasizing the gravity of the accusations against them. Meanwhile, Diane Chapman, Brandon's girlfriend, awaited extradition in Georgia to face similar charges. According to court documents, her white Honda Civic was used by the mother and son duo to drive to Edward Prater's trailer, where police alleged the crime unfolded. Investigators revealed that Brandon confessed to stabbing Edward Prater, his mother's ex-boyfriend, with a knife. He also claimed that Nancy struck Prater in the head during the attack. The motive for the crime, police say, was to steal tools from Prater's trailer, but the encounter escalated into a killing. Neighbor Joel Warren, who knew the victim, expressed shock and disbelief at the tragic turn of events.
He was a nice man. He kept to himself. First I seen the ambulance go up through there, and I know he's pretty old.
At first, Joel Warren thought that Prater may have died from a heart attack, but as the investigation unfolded, he learned that it was murder. Shocked and angry, Joel said that if Brandon and Nancy were found guilty, they should face the death penalty.
I think it should be a death penalty case. If they wanted to rob him, they could have just took his money and left, tied him up, and just left him instead of killing him.
Investigators revealed that Edward lived in constant fear of his ex-girlfriend, Nancy. Their relationship had been fraught with ongoing disputes and arguments over the years, which tragically culminated in his death. In July 2018, Nancy Cherie Hogan was convicted of first-degree murder, conspiracy to commit murder, robbery with a dangerous weapon, and conspiracy to commit robbery with a dangerous weapon. She was sentenced to life in prison without the possibility of parole. Brandon Hogan pleaded guilty to second-degree murder in December 2017, and was sentenced to 25 to 30 years in prison. Brandon's girlfriend, Diane Chapman, was also charged with the crime. In October 2021, Glenn Theodore Curry Jr., 36, and Brandy Shea Curry, 32, were charged with the murder of 31-year-old Jacob Breyer Black in Anderson County, South Carolina. During their court appearance, the couple faced a visibly shaken courtroom, with Black's fiancée expressing that such a tragedy should never have occurred, Jacob. The judge denied bond for both suspects, resulting in continued detention at the Anderson County Detention Center.
He was a really, really good person. And there was no reason for it.
Jacob Black's fiancée delivered an emotional plea in court as she came face to face with Glenn Curry Jr. and Brandy Curry, the couple accused of taking his life.
What happened to him, he did not deserve in any way. And for no reason do I believe that either one of them need to ever get out. I know that's not going to bring him back, but they don't deserve any different.
On October 11th, 2021, Anderson County deputies discovered Jacob Briar Black in a ditch along Griffin Road near Belton, South Carolina. He had suffered at least one gunshot wound. Following an investigation, authorities arrested Glenn Theodore Curry Jr. and Brandy Shea Curry, charging them both with murder in connection to Black's death.
We wouldn't want any other family in our community or this county or our state to have to go through what our family's been exposed to in the last 24 hours.
During their court appearance, the couple addressed the court, but neither provided any explanation or insight into the crime they were accused of committing.
I'm so sorry. That don't even cover it, I know. But I just wanted y'all to know that this was no way planned. I'm so sorry. Didn't really hurt it.
Jacob Black's family immediately addressed the judge, describing Glenn Curry Jr. and Brandy Curry as dangerous individuals. They passionately pleaded for the couple to remain behind bars, emphasizing the threat they believed the pair posed to the community.
We don't want any other family to have to go through such an act this horrendous and suffer like we have.
Following their arrest, both were charged with murder and possession of a weapon during a violent crime. They were denied bond and remained in custody at the Anderson County Detention Center. A 22-year-old woman, charged with driving under the influence and causing the death of a Kerman father, entered a plea of not guilty in court. The tragic crash marked her second arrest for extreme drunk driving in just 2 months, yet there remains a possibility that she could be released from jail this month without having to post bail. The victim, 59-year-old Jeff Nazaroff, never stood a chance. He had the right of way, and his dump truck was only about 500 feet from reaching its destination when disaster struck. A Jeep, driven by Dylann Juarez Calderon, ran a stop sign, crashing into Nazaroff's truck and forcing it into a tree. The collision claimed his life instantly. California Highway Patrol officers quickly apprehended Calderon at the scene, adding to the mounting evidence against her.
Ms. Juarez Calderon will enter a plea of not guilty to all charges and denial to any and all enhancements.
Dressed in a green jail jumpsuit, Dylann Juarez Calderon made her first court appearance, facing serious charges stemming from the crash and a prior drunk driving incident in February 2022. Both cases highlight her alarming pattern of behavior behind the wheel. In both incidents, Calderon was accused of driving under the influence and crashing into objects, with blood alcohol levels far exceeding the legal limit. In February 2022, her BAC was measured at 0.30. In the latest crash, it was recorded at 0.25, at least 3 times the legal limit. Despite these alarming levels of intoxication, Calderon was on the road without a valid driver's license. The California Highway Patrol had already revoked her privilege to obtain one after her first DUI.
It surprises me that she didn't have a license at all, and she's in the car, and then driving a second time under the influence without a license. That's aggravating circumstances. That's egregious conduct.
There is a public safety assessment that was prepared by probation, and they are recommending OR.
Legal analyst Tony Capozzi anticipated that the judge would require Dylann Juarez Calderon to post bond for her release, given the severity of her charges and her history of repeated offenses. However, under California law, all individuals are entitled to bail unless deemed a danger to the public or a flight risk. Her bail was increased from $112,000 to just above $188,000.
In this particular case, with a 0.30 just months ago, and now a 0.25, and she kills someone, it's pretty clear she's a danger to the public.
In January 2024, Dylann Juarez Calderon, then 24, was sentenced to 10 years in prison for her role in a fatal drunk driving incident that occurred in April 2022. She pleaded no contest to charges including gross vehicular manslaughter, driving with a suspended license, and driving under the influence. Caitlin Ridgway, who was charged with the murder of former county deputy William Clifton, along with a boy, made her first court appearance. The 18-year-old faced an open count of murder alongside 18-year-old Will Welch Jr. in connection with Clifton's death. According to court documents, Ridgway had sought protection from Clifton the previous year. The documents reveal that the two were in a relationship, and Ridgway accused Clifton of harassment. She claimed he had sent her threatening images of guns and pills and had shown up at her workplace. The situation escalated, with Ridgway also stating that Clifton had tied her to a bed on 2 separate occasions. Clifton's body was discovered in the early hours of July 7th at Woodlands Park. He died from multiple gunshot wounds and blunt force trauma to the head. 1 week later, Jacksonville police arrested Will Welch Jr. in connection with the incident. Ridgway and Welch were students at Jacksonville High School until April of that year. Clifton, the victim, had worked as a school resource officer at Southwest High School. In February 2016, a protective order was issued against Clifton, stating he must stay away from Ridgway and her family for a year. At that time, Clifton resigned from his position at the sheriff's office. Neighbors living near Ridgway's former home were shocked by the news of the crime.
It's a little unsettling that I've lived here and then she lived right there, and she never really came outside and talked to anybody. She'd ride her bike down to someplace.
In November 2019, Caitlin Ridgway entered an Alford plea to charges of second-degree murder and robbery with a dangerous weapon in connection with the 2017 death of former Onslow County Deputy William Clifton. Ridgway was sentenced to serve between 24 and 32 years in prison. Her co-defendant, William Welch Jr., pleaded guilty to the same charges in March 2019 and was sentenced to 13 to 16 years in prison. Daja Thaxton's family and friends were left heartbroken after her tragic death, which occurred when her boyfriend, Steve Gue, pushed her down the stairs. As the court session began, the judge took a moment to speak directly to Thaxton's family. He explained that the defendant, Gue, had accepted a plea deal, and while the following sentence may not feel like justice to them, it resulted from that agreement.
She was a really great person. She was the most genuine friend I ever had. She was always there for me.
The courtroom was packed with friends and family of Daja Thaxton, all gathered to support her and seek justice for her tragic death.
I don't understand why stuff like this happens to such good people.
A series of screaming and loud interactions, the breaking of a door, the breaking of a mirror.
Her boyfriend killed Thaxton, Steve Gue Jr. According to the defense, Thaxton arrived at Gue's home around 5 a.m., where the two got into an argument inside the house. The confrontation escalated, and it was during this altercation that Gue pushed Thaxton down the stairs, leading to her tragic death.
It was an accident. I never meant for Daja I never meant for nothing to happen to her.
Tears streamed down Gue's face as he stood in the courtroom, visibly emotional. Meanwhile, Thaxton's mother, filled with grief and sorrow, had one thing on her mind: justice for her daughter.
Just give me any kind of peace. That's all I'm asking for.
Strong man putting his hands on a woman that he's in a loving relationship with, and as a result, that woman is dead.
Gue's lawyer pleaded with the judge to avoid sending him to prison, urging a lighter sentence. However, the judge ultimately sentenced Steve Gue Jr. to 3 years in prison. While the judge acknowledged that Gue did not intend to kill Daja Thaxton, he stated that he could not overlook the facts of the case. Although Steve Gue Jr. was sentenced to 3 years in prison, there is a possibility that he could be released before serving the full term. In July 2012, Carmen Collins from Kathleen, Georgia, was charged with the murder of her younger sister, India Collins, and setting their family's house on fire to hide the crime. The incident occurred when their parents were away. India discovered Carmen packing to run away and attempted to stop her, threatening to inform their parents. In response, Carmen retrieved her father's .40 caliber handgun, chased India through the house, and shot her. Afterward, Carmen poured gasoline around the house and set it ablaze, intending to make it appear as though India had in the fire. She fled with the family dog to Columbus, where she was arrested 2 days later. In court, her parents sat in the front row, visibly tearful, while Carmen remained expressionless. Her lawyer, Nick White, shared that the family deeply felt the emotional weight of the hearing as they walked into the courtroom. Carmen passed her parents without a word and approached Judge Kathleen Lumsden's bench, where she pleaded not guilty. The charges included burglary and theft, which occurred at the end of February. She faced 2 counts of murder, 2 counts of possession of a firearm, along with charges of aggravated assault and first-degree arson.
It's pretty standard procedure, so this is a case we'll get in the courtroom, we'll present the evidence in court, and we look forward to it.
I feel confident with the defense, and it would be inappropriate for me to name names, but it's fair to say that we think others were involved, and we think that that will exonerate my client.
Initially, Carmen denied the allegations, but later admitted her guilt to her attorney. In July 2013, she pleaded guilty to malice murder and arson. Superior Court judge sentenced her to life in prison, with the possibility of parole after 30 years. Cheyenne Maddox, a mother accused of starving her son, Kadaris Maddox, to death, appeared in court to request a reduction of her $1 million bond. She faced 5 counts of aggravated abuse and murder in connection with her son's tragic death. Kadaris, who suffered from cerebral palsy, was unable to walk, talk, or eat on his own, making him entirely dependent on his caregivers. The court heard testimony from Clarksville homicide detective Brian Hughes, who responded to the Maddox home on July 6, 2022, after Cheyenne reported finding Kadaris dead. According to Hughes, Cheyenne called 911 and claimed Kadaris had accidentally suffocated himself with a blanket while she was out searching for the family dog. However, the autopsy revealed that Kadaris had died from severe malnutrition. During his testimony, Hughes stated that medical records showed Cheyenne had canceled her son's in-home medical care appointments in the month leading up to his death. Through interviews with Kadaris' medical providers, Hughes uncovered a history of neglect and abuse. Cheyenne reportedly told Hughes she had recently fed Kadaris orange juice, which she often blended to help him swallow, but this claim starkly contrasted the autopsy findings.
I anticipated to find some kind of food processor or blender to facilitate that liquid night.
Did you find one?
I was unable to.
The defense argued that Cheyenne did not have a significant criminal history and had never previously lost custody. Despite these arguments, the judge was not swayed and declined to lower her bond. Cheyenne has remained in custody with a bond set at $1 million. A Great Falls woman faced sentencing for her involvement in the tragic death of Megan Merriweather, a Great Falls High student, in September 2016. Brianna Coombs pleaded guilty to felony robbery, admitting her role in the events that led to Merriweather's death. During the sentencing hearing, Judge John Kutzman expressed his outrage, stating that the case filled him with anger whenever he thought about it. Coombs acknowledged she intended to rob Merriweather, but claimed she never anticipated the situation would result in her death. According to court documents, Coombs and her boyfriend Joseph Knowles visited Merriweather under the pretense of purchasing marijuana. However, a fight broke out during the exchange between Coombs and Merriweather. During the altercation, Knowles seized Merriweather's knife and stabbed her. The court sentenced Coombs to a term of years with 40 suspended, reflecting her role in the crime, but distinguishing it from the direct act of murder. Joseph Knowles, who carried out the stabbing, received a much harsher penalty, 60 years in the Montana State Prison. On April 28, 2023, Samantha Miller and Eric Hutchinson celebrated their wedding surrounded by friends and family in Folly Beach, South Carolina. The newlyweds were radiant with joy as they departed their reception in a low-speed golf cart, ready to start their life together. Accompanying them were Eric's stepfather, Ben Garrett, and his son, Rogan. The group traveled legally on a well-lit golf cart, heading to a nearby rental property. What began as a night of celebration quickly turned into a nightmare when Jamie Lee Komorowski, 27, crashed into the back of the cart at 65 miles per hour in a 25 miles per hour zone. Komorowski, heavily intoxicated with a blood alcohol content of 0.26%, caused a collision with the golf cart. The crash claimed the life of Samantha Miller, who was still in her wedding dress. Eric Hutchinson suffered life-threatening injuries, including brain trauma and multiple fractures. Ben Garrett and his son Rogan were also severely injured. Garrett later recounted waking up in the hospital with no memory of the crash. crash and being told the horrifying details of what had happened. Emergency responders at the scene could do little to change the grim outcome. Samantha was pronounced dead on site, while the other passengers were rushed to the hospital in critical condition. Jamie Komorowski was arrested at the scene and charged with reckless homicide and felony DUI causing death, as well as multiple counts of felony DUI causing great bodily injury. The severity of her actions and their devastating consequences drew significant media attention, sparking outrage within the Folly Beach community and beyond. Families of the victims, especially Samantha's and Arik's, were left grappling with immense grief, while survivors faced a long road to recovery.
While we were on the drive there, we were talking that night. You know, we were just listening to Sam and Eric talk, flirting with each other. Rogan and I were having conversations. We talked about the breakfast burritos at Berg's Market, how fantastic they were. And that's the last thing I remember that night. The next thing I knew, someone was tapping my shoulder, asking me if I knew where I was. And I remember opening my eyes and seeing all the lights and knowing that I was at the hospital. I had no idea how it got there or what had happened. The next time I woke up, I remember hearing Eric yelling in pain, just screaming, "It hurts, it hurts." There was so much chaos inside the ER. In and out of consciousness. I asked about my son, and one of the nurses came back, I think it was a nurse, I don't know who it was, told me that it didn't look good. And then a little bit later, when I woke up again, they came back and told me that they'd given me the wrong diagnosis. They had given me Eric's diagnosis instead of my son. And that my son was with my wife, and they'd be taking me back there. The hospital staff eventually took me back to go see my wife and my son. And that's when my wife told me that Sam didn't make it. They didn't know if Eric was going to make it through the night, to make sure that they got to their rental property and have their money. Your Honor, I had road rash all over my body. That night, I had no idea what the extent of my injuries. I didn't want to move. I couldn't move. Had stitches in my forehead, an open hole in my knuckles on my left hand, giant gash on my right wrist, and I couldn't walk, couldn't even stand. I actually, when they released my son, I told them I was going home, and the doctors told me, well, if you can stand, you can go home. It was a struggle to sit up, and I knew that I'd be staying longer. After the first couple of days of my wife getting pretty upset with the condition that I was in, Dr. Hink at MUSC and her team took me in for surgery again. Fixed up the stitches on my forehead and also gave me a fish skin graft on my right wrist. I then spent the next 9 days recovering from injuries and trying to walk. I separated my right SI joint, cracked my sacrum, and tore the labrum in my right hip. I had to practice sitting in a chair so that I could show the doctors that I could fly home and join my family in Bootleg. When I returned home, I was referred to the University of Utah Burn Clinic and instructed to see a general practitioner and orthopedic surgeon. I had more MRIs and x-rays due to problems in my pelvis, my back, and my neck. That is when they found that I had broken vertebrae in multiple places in my back and my neck. And I still have issues there today. I spent 6 months in physical therapy until my insurance told me I ran out of visits. Your Honor, this is just a list of the physical injuries, and most of them I'm still dealing with. You'll need to have a hip replacement, fusion of my SI joint, and fusion of my vertebrae in my neck and my back. This will continue to be a burden that we'll have to deal with financially, physically, and emotionally for the rest of my life. The hardest part of this, the whole incident, is the mental and emotional side. Your Honor, my wife and kids saw me in a state they should never see me in. I am unable to be the husband or father that I was or wanted to be in the future. I should be seen as their protector, their rock. My kids and my wife now watch me go downstairs to make sure I can make it. They come out and carry things in from my truck or from our cars because I can't carry them in.
In the months following the crash, Ben Garrett shared the profound impact the tragedy had on his life. He detailed his physical injuries, requiring 9 days in the hospital and months of grueling physical therapy. Garrett described the frustration and sadness of losing his mobility and ability to engage in everyday activities with his family.
And I always go back in my mind to that night, me being the driver, if there was something that I could have done. Something I could have done different. I replay the events leading up to it constantly in my mind. Like Rogan going back to get Sam's cell phone. How long we sat at a stoplight listening to a song. Could I have gone a different route? Could I have gone slower? Could I have gone faster? These are the things that I struggle with every day. Every day I am in constant pain and have no way to get the relief that I need.
Beyond the physical pain, the emotional toll was immense. Garrett struggled with feelings of guilt as the driver of the golf cart, replaying the events of that night in his mind, questioning if anything could have been done differently.
From the very bottom of my heart, with every fiber in my being, how sorry I am, and that I take full responsibility for my actions. Hopefully one day you will be able to forgive me, but I know forgiveness must be earned.
Nearly 2 years later, in December 2024, Jamie Komorowski pleaded guilty to all charges.
Sam and I had a bond that was very different and very amazing, and we both had each other's backs all the time.
You took such a beautiful person away. She was loved by so many. I think about that night every single day.
During the sentencing hearing, Samantha's mother, father, and groom delivered powerful victim impact statements, expressing their pain, grief, and anger over Komorowski's decision to drive while intoxicated.
Based on what has been presented to the court, I find the following appropriate in the nature of sentencing. On the offense of reckless driving, reckless homicide, which is 2023 GS 103895, you're sentenced to the State Department of Corrections for a period of 10 years and $5,000, provided upon the service of 10 years. Yeah. On both counts of felony DUI, great bodily injury, you're sentenced to the State Department of Corrections for a period of 15 years and $5,100, provided upon the service of 15 years. And on the offense of felony DUI with death, you're sentenced to the State Department of Corrections for a period of 25 years and $10,100, provided upon the service of 25 years. These sentences are concurrent with one another. You'll get credit pursuant to 241340 if that becomes applicable. And I think it is appropriate, and I queried Mr. Finch for a particular reason. It was not random. Our state legislature, in their infinite wisdom, amended 241340 to allow for time spent on monitored house arrest. And it was contemplated that a person get credit when they are basically in jail at home. And based on how Ms. Komorowski's home detention was structured, she was in jail, but for being at home. And I think it is appropriate that she receive credit for any time served on monitored house arrest or home detention. Those terms in my mind are interchangeable. From the period of 3/1/2024 through the present, and we'll calculate that and place it on her sentencing sheets. Again, these sentences are concurrent. I've ordered the ATU if it is available to her, and she will get credit for any time served pursuant to 24-13-40. Thank you all for your time and your attention.
Komorowski was sentenced to 25 years in prison, the maximum penalty for felony DUI causing death. While the sentence brought a sense of closure, the victims' families emphasized that no punishment could undo the damage or bring Samantha back. On the evening of June 23, 2022, a quiet night in Grand Rapids, Michigan, was shattered by a tragic and senseless act of violence. Two men, Tony Vaughn and Freddie Lusk, lost their lives in a brutal double homicide that led to the arrest and conviction of 26-year-old DeAndre Darrell Kraft. The murders occurred in a residential area with evidence collected from surveillance footage, including ring cameras and a nearby store. These videos captured key moments that tied Kraft to the scene, alongside at least one other accomplice whose role remains under investigation. Investigators quickly concluded that the murders were premeditated and involved firearms that Kraft, as a convicted felon, was prohibited from possessing. Shortly after the murders, law enforcement focused on Kraft as the primary suspect. His extensive criminal record, including 5 prior felonies and 8 misdemeanors, made him well known to authorities. Kraft was arrested and charged with 2 counts of first-degree murder, felon in possession of a firearm, carrying a concealed weapon, and 3 counts of felony firearm. His arrest marked the beginning of a legal process that sought justice for the families of Vaughn and Lusk. Kraft's trial commenced in early 2024, with prosecutors presenting a compelling case that included video evidence, witness testimonies, and forensic findings. The footage from the scene played a pivotal role in demonstrating Kraft's involvement in the crime. Despite efforts by the defense to challenge the evidence, the jury was convinced of Kraft's guilt. After careful deliberation, they returned a verdict of guilty on all charges.
Okay, well, Mr. Kraft, at this point you are 26 years old and you have 5 prior felonies and 8 prior misdemeanors, and we're here for you to be sentenced regarding this incident that occurred back in June of 2022, June 23rd to be exact, where you, along with at least one other person, apparently made the decision to end the lives of Mr. Lusk and Mr. Vaughn. You were found guilty after evidence was presented to a jury. You had a jury trial. There was a lot of evidence presented, including some ring camera footage. There was some video from a store from across the street. That, along with all of the other evidence presented, led to you being convicted of this double homicide, as well as being a felon in possession of a firearm which you were ineligible to possess, carrying a concealed weapon, and then 3 counts of felony firearm.
On July 24, 2024, Kraft faced sentencing. Family members of the victims delivered powerful and emotional impact statements, describing the enduring pain and loss caused by the murders of Vaughn and Lusk.
Today I'm very angry, and I just want to shout it out, but I can't let this be about how I feel. I'm standing here today in this court to tell you who my father, Tony Vaughn, is and what he meant to his daughters and family. The way he was taken from our lives had nothing to do how he lived his life. I refuse to let this horrible way he left this world be the end to his story. I will not let people remember my father as only a victim. When family and friends think of my father, they always remember smiling and caring family man. Tony is so much more than my dad. He is a son, a grandfather, brother, uncle, and cousin, and a great friend. My father is a girl dad. Long before it was popular to be, and he was always proud of that title.
The judge expressed sympathy for the victims' families, while condemning Kraft's actions as simply inexplicable.
Mandatory sentences in this case, so what I'm going to do is sentence you in accordance with those mandatory sentences, which means that for counts 4, 5, 6, and 7, which are this carrying a concealed weapon and the 3 felony firearm charges, You're going to receive 716 days credit for all of those. For the felony firearms, I'm sentencing you to the 2-year mandatory sentence. For the carrying a concealed weapon, I am sentencing you to 4 to 5 years in the Michigan Department of Corrections, which will be served consecutively to the felony firearm charges. I'm sorry, the CCW will not be consecutive. It will be running concurrently. In addition to that, for counts 1 and 2, which are the homicides of Mr. Lusk and Mr. Vaughn, I'm sentencing you to the mandatory sentence of life in prison without parole. And this, you'll receive credit for 0 days. This sentence will have to run consecutively to the felony firearm charges. And I'm also sentencing you to, for the counts 3 and 4, which are the felon in possession and the carrying concealed weapon, I'm sentencing you to 4 to 5 years in the Michigan Department of Corrections. That's in accordance and within the guidelines scored for those particular counts. In addition to that, Mr. Kraft, you will be responsible for $476 state minimum cost, $130 crime victim rights assessment, and $1,000 in court costs.
Kraft was sentenced to life in prison without the possibility of parole for the murders, alongside concurrent sentences of 4 to 5 years for firearm-related offenses. He was also ordered to pay over $1,500 in court fees. In the fall of 2011, a chilling web of deceit and murder unraveled in rural Ohio, exposing a sinister plot orchestrated by Richard Beasley and his accomplice, Brogan Rafferty. At first glance, the scheme seemed innocent enough. Job advertisements posted on Craigslist for a caretaker position on a remote farm. The job promised housing and a good salary, attracting individuals desperate for work and a fresh start. But beneath the guise of opportunity lay a trap designed to exploit and destroy. One of those drawn in was Scott Davis. He responded to the ad, unaware he was walking into a carefully constructed ambush. On November 6, 2011, Davis met Beasley and Rafferty, who presented themselves as potential employers. Beasley, posing as a benevolent preacher, led Davis to an isolated stretch of woods, claiming he wanted to show him the property. Moments later, Beasley pulled out a revolver and aimed it at Davis. In a terrifying twist, the gun misfired. Seizing his only chance, Davis fled into the woods, dodging bullets as Beasley gave chase. Miraculously, Davis escaped and found help, becoming the key witness in the case that would unravel a string of murders. Davis's escape exposed the horrifying scope of Beasley's crimes. Investigators uncovered the bodies of Ralph Geiger, David Pauley, and Timothy Kern, all of whom had responded to similar Craigslist ads. Each victim had been lured to secluded locations, murdered, and buried in shallow graves. Beasley had targeted vulnerable individuals, men who sought a fresh start, only to meet a tragic end. The stolen belongings of the victims were later found in Beasley's possession, adding to the damning evidence against him. During the trial, Beasley tried to rewrite the narrative, portraying himself as a victim of conspiracy and accusing law enforcement of fabricating evidence.
Now, would you describe in your own words then what happened after you got to the location where you were going to actually physically get out of the car and look at the farm?
Well, we went down to the farm and looked at the farm. And he was undecided as to whether or not he was going to take the job or not. He said, let me think about it. He said, by the time we get back to town where my truck's at, I'll have you an answer. So we left, and we went back up the drive. And instead of making a right to go directly back to town, Brogan made a left. And I asked him, I said, Brogan, why are we going this way? He said, well, this goes along the back of the farm, and so he can see where the rest of the farm's at. And we go down this road, and this road is trashed. There's been a partial mudslide or something, and there's gravel and there's ruts. And Brogan's car is dragging real bad. And he said, guys, we're never going to make it to the bottom with all this weight in here. I thought we could get through. I'm going to let you off down here, go around and turn around, and we'll go back the other way. And at that point, he had picked a wide spot in the road, and he let Scott and I out, and he went down the hill to turn around and come back.
You mean Brogan did?
Brogan did. He was driving the car, yes.
So he drove the car down to turn the car around.
To turn the car around.
And you and Scott Davis did what?
Scott Davis then pulled out a revolver and pointed it at my head. And I threw my hands up and about urinated in my pants. And I just said, why? And he explained why. He said, brother, you're a weak link.
Beasley claimed that Scott Davis, the man who had miraculously escaped his murder attempt, was the actual aggressor. According to Beasley, Davis turned a gun on him during what was supposed to be an innocent visit to the farm for a job opportunity. Beasley alleged that Davis pulled out a revolver, pointed it at his head, and accused him of being a weak link or a potential informant.
He said you were a weak link, brother.
Yes.
While pointing his gun at you, what happened?
It misfired 3 times, about 2 feet from my face. And I ran in the woods, and he ran after me. I fell. I'm just not in a condition to run. He got on top of me. We were wrestling over the gun. It misfired, then it fired, then it misfired. So 1 time out of 6 times, and at a glance, I would say it was an old gun. It was pitted. That's all I can remember, and it was a revolver. And he had his 6 shots, and he yelled when it went off, and when it went off, it went bang quick. In other words, he was continually pulling the trigger. So he yelled, and I pushed him away, and he just kind of pushed away, and I said, that's your 6. So if he was going to kill me, he had to do it with his hands.
Did you know whether or not he was apparently struck with one of the bullets?
I thought he was from the way he reacted, and I thought it hit him in the arm. Because of the way we were wrestling around, I had one hand on his hand, and the gun was pointed up.
He described the scene with vivid detail, claiming that the gun misfired multiple times before a struggle ensued. Beasley painted a picture of desperation, stating that Davis wrestled him to the ground and fired the weapon during their scuffle. However, Scott Davis's harrowing testimony and Brogan Rafferty's detailed account as an accomplice painted a far darker picture of Beasley as a manipulative mastermind who preyed on the desperate.
I say here today, officially and for the record, I have killed nobody.
The defendant's statement was pretty much what we would expect. I can only say that the arrogance continues. Just disgusting.
He was just unbelievable, unbelievable. I mean, I can't believe the guy would still carry on.
Even on his sentencing day, he continued to deny the charges.
With regard to count 1 of the indictment, aggravated murder regarding the death of Ralph Geiger, we the jury being duly impaneled and sworn, do hereby find that the aggravating circumstances that the defendant was found guilty of committing do outweigh the mitigating factors presented in this case by proof beyond a reasonable doubt. We therefore unanimously find that the sentence of death should be imposed on Richard James Beasley. On count 2 of the indictment, count 4 of the indictment regarding David Powley, we the jury being duly impaneled and sworn, do hereby find that the aggravating circumstances that the defendant was found guilty of committing do outweigh the mitigating factors presented in this case by proof beyond a reasonable doubt. We therefore unanimously find that the sentence of death should be imposed on Richard James Beasley. Regarding count 7 of the indictment pertaining to Timothy Kern, we the jury being duly impaneled and sworn, do hereby find that the aggravating circumstances that the defendant was found guilty of committing do outweigh the mitigating factors presented in this case by proof beyond a reasonable doubt. We therefore unanimously find that the sentence of death should be imposed upon Richard James Beasley. Each of these forms is signed this 20th day of March 2013 in ink and signed by 12 jurors.
In 2013, the jury saw through Beasley's lies. He was convicted on multiple counts, including aggravated murder, kidnapping, and robbery, and was sentenced to death. Rafferty, tried as a minor, received a life sentence without parole. In September 2023, Allegan County Deputy Dylann Kibbe responded to reports of reckless driving in Dorr Township, Michigan. Upon arriving, he encountered 35-year-old Christopher Jarreau, who appeared intoxicated and exhibited erratic behavior. While Deputy Kibbe attempted to perform a standard field sobriety test, the situation escalated as Jarreau became uncooperative. In the ensuing confrontation, Deputy Kibbe was injured and lost consciousness. The injuries required medical intervention and resulted in long-term effects, including the loss of his senses of taste and smell. Michigan State Police troopers on the scene were able to restrain Jarreau using a taser. Following his arrest, troubling comments attributed to Jarreau raised concerns about his mindset during the incident.
There was interaction with Deputy Kibbe for purposes of investigating what appeared to be some form of careless or reckless driving, and the interaction quickly turned for the worse. And it was noted that Jarreau's behavior was erratic, aggressive, and unstable. And at that time, Deputy Kibbe was doing his best to administer the standard field sobriety test, at which point Mr. Jarreau decided he would no longer participate, and he began to walk away, really leaving Deputy Kibbe with no other choice but to try to stop that from happening and complete his investigation. Essentially, without provocation, Mr. Jarreau turned around and struck Deputy Kibbe so hard that he immediately lost consciousness. It's also noted that Mr. Jarreau was acting erratic, uncooperative, and aggressive. In respect to the continuing behavior, it was only after a separate enforcement officer, Trooper Casey, drew his taser that Mr. Jarreau complied and went to the ground. The circumstances are such that in this particular incident, apparently Mr. Jarreau had been drinking. His parents were interviewed, and both of them indicated that his behavior was getting worse. In fact, it appears, based on CFJ 284, page 4, that they had told him that he shouldn't be drinking.
In the months that followed, Jarreau faced multiple charges, including assault with intent to murder, resisting and obstructing an officer, and operating while impaired. He eventually pleaded no contest to several charges in November 2024, leading to the dismissal of others. During the proceedings, the court reviewed Jarreau's extensive history of mental health struggles, including diagnoses of bipolar disorder, schizophrenia, and major depressive disorder. It was revealed that Jarreau had a pattern of self-medicating with alcohol and drugs when off his prescribed medications, which often triggered violent outbursts.
Has had mental illness battles since age 17. During his lifetime, his family has sought various treatment through different avenues, including inpatient and outpatient treatment at Pine Rest and Forest View. And at some point in time, Mr. Jarreau was even experiencing hallucinations resulting in paranoia. Instead of utilizing known methods, however, to a large degree, Mr. Jarreau would self-medicate, and he would utilize alcohol and other substances either when his medication was no longer available or he chose not to take that medication. And that is the crux of the issue in this particular case. Mr. Jarreau has a very unique disposition, to the extent that if he does not take his medication, it appears that he acts aggressive and violent. As it relates on page CFJ 284, page 2, the defendant has a documented history of failing to consistently participate in mental health services. He discontinues contact with the mental health programs, stops taking his psychotropic medications, and returns to using drugs and alcohol. He further has an extensive history of misusing alcohol and often becomes aggressive and violent.
His criminal record included numerous offenses, including domestic violence and assaults, reflecting a long-standing issue of volatile behavior.
As I look over your criminal history, you have multiple instances of alcohol and violence. Number 5 of 24, domestic violence. Number 6 of 24, dating back to 2007, police officer, assault, resisted, struck, operating while intoxicated, second offense. 2009, attempted police officer, assault, resist, obstruct, domestic violence. 2010, number 14 of 24, attempt home invasion, first degree. Number 17 of 24, 2013, domestic violence. Another domestic violence in 2013. May of 2013, domestic violence, second offense. August of 2013, assault by strangulation. March of 2014, assault and battery. August of 2014, assault on a prison employee.
During the sentencing hearing, Deputy Kibbe delivered an emotional victim impact statement, detailing the profound and permanent impact the attack had on his life and career. The court acknowledged Jeru's mental health challenges, but emphasized the need to prioritize the protection of society and deterrence of similar crimes. While Jeru expressed remorse and apologized for his actions, the judge noted the severity of the assault and Jeru's history of violent behavior in determining the sentence.
Was to focus on punishment of the offender and protection of society. And in doing so, it is the court's hope that this will perhaps deter others from engaging in similar conduct and or encourage others to maintain a healthy medication regime when they know they need that in order to lead stable lives. I do hope that you get the services that you need in the Department of Corrections. It is therefore the sentence of the court in file 24-26413 FC that the defendant is sentenced in count 2 police officer assault, resist, obstruct, causing serious impairment as a fourth habitual offender to the Michigan Department of Corrections for a period of 19 years to 40 years with credit for 455 days served. This sentence will run concurrent to counts 5 and 6. You are to pay a crime victim's assessment fee in the amount of $130. You are to pay court costs in the amount of $300 and a $68 state cost. In respect to count 5, police officer assault, resist, obstruct as a fourth habitual offender, it is the sentence of the court that Mr. Jeru be sentenced to the Michigan Department of Corrections for a period of 2 years to 15 years with credit for 455 days served. This count will run concurrent to counts 2 and 6. There is a $68 state cost in respect to count 5. In respect to count 6, operating intoxicated, third as a fourth habitual offender, it is the sentence of the court that Mr. Jeru be sentenced to the Michigan Department of Corrections for a period of 3 years to 10 years with credit for 455 days served. This count will run concurrent to counts 2 and 5. You may not drive a motor vehicle while your license is suspended, and your license will be suspended per the Secretary of State. You must comply with the vehicle immobilization as ordered by the court. You must pay restitution, $68 in state costs. If there is any restitution in relation to any of these matters, that issue will be preserved. However, in reviewing the report, I observed that I believe Deputy Kibbe indicated that all of his fines were taken care of.
On December 10, 2024, Jeru was sentenced in Allegan County Circuit Court. The judge imposed concurrent prison terms, 19 to 40 years for assaulting a police officer causing serious impairment, 2 to 15 years for resisting and obstructing an officer, and 3 to 10 years for operating while intoxicated. Jeru received 455 days of credit for time already served. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.